All rise. Court of Appeals Division 1 is now in session. Thank you. You may be seated. This is the time set for argument in Mills versus Arizona Board of Technical Registration. Our case number 1 CACV 200510. Each side will have 20 minutes. Appellant will be responsible for reserving any time that you'd like for rebuttal. These proceedings are being video recorded and audio recorded. We would appreciate it if you would state your name and your client when you approach the podium for the first time. We have read the briefs. We've conferenced this matter. We hope we're familiar with the arguments that you're going to present, but we look forward to hearing from you. And with that, you may proceed.
Good morning, Your Honors, and may it please the Court. My name is Paul ABOTR. I represent the plaintiff's appellants in this matter. Last year, for the first time in his career, in his lengthy career, Greg Mills's rights to pursue his profession and to call himself an engineer were called into question under Arizona's engineering practice statutes. The board told him he was potentially in violation of 3 engineering practice statutes that carry misdemeanor penalties. The board's reviewers then opined that he was in violation of those statutes by doing his work, by calling himself an engineer, and by operating his own firm, Southwest Engineering Concepts. Based on those reviews, the board asked Greg to enter into a consent agreement in order that said he had violated the statutes, imposed a $3,000 fine, and required Greg to stop working and stop speaking in violation of the law. And the board was also willing to vote to double the amount of those fines in the proposed consent agreement in order. To determine whether those statutes can constitutionally be applied to him, Greg filed suit under the Declaratory Judgments Act, the DJA. That's precisely what the DJA was meant to do, to give people a forewarning of what the law is and to ensure that no one has to, as the court has said, pull the trigger to discover if the gun is loaded.
Counsel, let me ask you, you say it's precisely what the Declaratory Judgment Act was intended to do. What's your best case for the thought that the Declaratory Judgment Act eliminates administrative exhaustion?
Your Honor, Manning is the best case that says that administrative exhaustion does not apply to this kind of DJA case. This court has frequently said, of course, that the DJA is not a substitute for administrative appeals. But that's not what this case is. All the parties agree there's not been a final administrative decision here. Manning recognizes, as do a number of other cases, but Manning is the one I think that puts it most clearly, that there are just some kinds of cases, some kinds of claims that boards can't adjudicate, and specifically, they cannot determine the constitutionality of statutes. That is something that only a board can do. That's something that only a court can do. Only a court can declare an act of the legislature to be constitutionally invalid. And that's what Greg is seeking here.
Aren't you talking about, though, a challenge as applied?
It is an as-applied challenge, Your Honor, but...
And in that context, don't we want a factual development? Wouldn't it be helpful to have this agency that's been authorized to conduct these types of investigations to do a factual investigation so there's a record that can then be addressed in Superior Court?
It would not, Your Honor, and for a couple of reasons. First of all, of course, facts are critical in an as-applied challenge, and we don't disagree with that.
You're saying develop it in Superior Court.
Development is proper in Superior Court because those facts are being developed in furtherance of a claim that certain statutes are unconstitutional. And the relief sought here is a declaration that those statutes violate the Constitution and therefore are invalid as applied to Greg and Sinico, an injunction against their enforcement, and in this case also the award of nominal damages. And the board can't do any of those things. And it doesn't have a freestanding ability to determine facts. What the board does is it hears and determines complaints or enforcement matters. But that's not what this case is about. This case is about the constitutionality of the underlying statutes. And as Manning recognizes, and as several cases have recognized that Manning recognizes, boards simply don't have that power.
Yeah, so let me ask you, and I got ahead of myself in engaging on the Declaratory Judgment Act, but what was the dismissal here with prejudice or without prejudice?
Your Honor, the dismissal here was pursuant to Rule 12.1b and 12b6. So theoretically, they could be refiled, but those are permanent dismissals. As according to the court, the trial court's opinion here says dismissed for the reasons stated in the board's briefing. But that means that we cannot further pursue those claims under the board's theory right now, or again, the board's argument here is that Greg can't go to court except through an administrative appeal. That is, he has to sit back and he has to wait for a prosecution to come, to finish, and for them to impose a final administrative action on him. Then, and only then, according to the board, can he go to the courts and say, none of this is constitutional. The underlying statutes themselves are not constitutional.
And let me tell you why I ask you that, and I may ask it again because of that. We, of course, have an obligation to look at our appellate jurisdiction, and if something's dismissed without prejudice, typically we would not have appellate jurisdiction, and that's why I wanted to delve a little more deeply. You've described what you believe would be necessary for, according to the trial court, to press a claim in the trial court, what needed to happen that didn't happen. But does that mean the dismissal here is with prejudice or without prejudice?
Your Honor, my understanding is that it is with prejudice as to the claim today and potentially forever. Because, again, according to the trial court doesn't tell us much about with prejudice versus without. It says, according to the board, I agree with the board and everything the board said. And what the board said and what it argued again in its briefing here is that Mr. Mills cannot file a standalone lawsuit, that he has to wait for the board to make a final administrative action. Then and only then may he pursue an administrative appeal, and that's...
And I understand all that, but my question's a little different as to whether the dismissal is with or without.
Your Honor, my understanding is that it would be with prejudice because there's no, based on what the board has argued, there's nothing that Mr. Mills can do at this point to assert his claims in court other than through an administrative appeal.
Let me ask one more question, then I promise I'll leave you back to your presentation. But he could reassert his claims at another time, according to the Supreme Court. Is that fair?
Your Honor, it's not fair because he can't reassert his DJA claims. He can only assert his constitutional, according to the board, on the position of which the Superior Court granted or adopted. He can only assert his constitutional rights through an administrative appeal, which means that he cannot assert a standalone DJA claim, which is what all of his claims here are. So I take that as that must mean it's with prejudice as to claims under the DJA. And I don't know how else to answer that question, Your Honor.
This last time, I really appreciate it.
Again, Your Honor, the key issue here is the remedy. What Greg seeks is a judicial declaration that the statutes are unconstitutional, as applied to him, an injunction against their enforcement, and nominal damages. And the board is without the power to grant any of that sort of relief. Again, what is it that the board can do for Greg here? There's nothing that Greg can ask the board for, and nothing the board can give him. Again, their position is he has to sit back and wait to be prosecuted, and then he can do an appeal. Well, sit back and wait is not administrative exhaustion. Administrative exhaustion recognizes there are certain things that you can do before an administrative agency to potentially get the relief that you seek. That's cases like Moulton, that's cases like Valley Vendors, that's cases like the Bone or In re Bone case. In each of those cases, there was something that the person could do. So, for example, in Moulton was an application for a tax credit. The person could, and in that case literally did, apply to the board to receive a tax credit. And that is relief that the board, or that ADOR was empowered to give them. The Department of Revenue could give them the tax credit. And for that reason, the court said that's a government benefit that the board can give you, and you have to go through that process. Valley Vendors is a tax assessment case.
Isn't there an available remedy for someone with a complaint that goes to an administrative agency? Doesn't that person have a right to have their complaint adjudicated through that process?
No, Your Honor. The question is when it comes to Greg, the question is whether or not there's any administrative relief he can exhaust in the first place. And if the board can't give him what he wants, then there's nothing to exhaust. Greg is not required to sit back. Greg can't be required to sit back and wait. Not only is sit back and wait not exhaustion, sit back and wait also exacerbates his existing current constitutional violations, which is he is currently under threat. Every day that Greg goes to work is potentially another criminal activity. And Greg has the right under the DJA to get that cleared up at the beginning rather than sit back and wait at the end. And cases like the Planned Parenthood case of Tucson recognize that as well, where there are statutes that regulate a person in his speech and his occupation. That's what the DJA was designed for, to clear up the questions of legality as to that.
Counsel, if we accept your argument, what's left of administrative exhaustion if someone wants to?
Lots of things are left of administrative exhaustion, Your Honor. Where the board has the power to actually remedy the injury, administrative exhaustion can be required. And those are cases that involve the grant of or denial of a government benefit. Let's take this board, for example. This board grants licenses. Licenses are a government benefit. You have to go through the administrative process if you want to get a license. Similarly, the withdrawal of a license is the withdrawal of a government benefit, and you would have to go through that process. That's not what this case is. This case isn't about a license. Greg does not have a license. He's not seeking a license. His argument is essentially the board has to leave me alone, and leave me alone going forward. Again, this is not just I'm fighting this one complaint. This is my rights have been called into question, my rights to work and to speak have been called into question going forward.
Does your position depend on what the agency could conclude with respect to the scope of the statutes and rules? In other words, what if they found, hey, we thought it might have, but it really doesn't apply to it?
Your Honor, it does not, because that is not a binding conclusion of law as a declaration from this court is, and it's not a basis for an injunction, nor is it the basis for nominal damages. So although a board could make conclusions, none of those conclusions actually provide Greg the remedy to which he is entitled. Again, declaratory relief from the court laying out what his rights and obligations are under law.
And so your position is that the agency could sort of rethink its position. In other words, let's say day one, year one, statute and regs don't apply to your client. Day one, year two, they say, wow, we looked at this more thoughtfully, and it turns out that they actually do apply, and therefore your client's in charge.
That's correct, Your Honor. It's not binding on the agency the way a judicial declaration is binding on the. When a court construes the meaning of a statute, that's the meaning of the statute. When a board construes the meaning of a statute, the board can change its mind. And ultimately, that's the problem with this. Again, this is not a case in which Greg is fighting a one-off complaint. There is a complaint in this case. But Greg isn't fighting the complaint. Greg is looking for the prospective relief that he's entitled to under the DJA, and that's precisely the kind of relief that boards cannot give anyone because they are not courts and therefore do not have the authority to declare acts of the legislature to be in violation of the Constitution.
When you say not fighting the complaint, is it fair to say on the current record he's agnostic as to the complaint, as opposed he's neither conceding nor disputing?
That is correct, Your Honor. The complaint and the process that filed is the evidence of the ripe injury. It is the evidence that his rights have been called into question under the existing statute and under the DJA. He is entitled to a construction, the precise language I believe is a construction of the statute and a declaration as to their legality. So again, nothing that Greg is seeking prevents investigation. Nothing that he's seeking even prevents the resolution of a complaint. It would, however, require the resolution of a complaint in compliance with the law as declared by the court, now and going forward.
You've asked that the court take judicial notice of certain items. Do you wish to be heard on that?
Your Honor, the item that we asked this court to take judicial notice of was a vote by the board subsequent to that essentially withdrew the doubling of the amount of fines. We wanted the court to be aware of that. We don't think it changes anything because Greg still has a ripe injury, whether it's no matter what. He still has a ripe injury. Maybe that suggests that there's not an imminent hearing in this case, but it doesn't matter. Greg's rights have already been called into question, and that's what standing requires.
And there is no hearing scheduled, requested, pending?
That is correct, Your Honor. Your Honor, if I may, I'd like to reserve the balance of my time for rebuttal.
Sure.
Thank you.
May it please the court. My name is Greg Harris from the law firm of Lewis Roca, and I'm here on behalf of the Board of Technical Registration and the members of the board who were named in the lawsuit, as well as the executive director. Thank you very much for the opportunity to appear before you today. A couple of things that I would like to sort of start with. One is this two themes. The legislature has made a choice for how this board is to carry out its function and how it carries out its duties to protect the public. And the second that I want to focus on is the idea that this concept of exhaustion and the availability of an adequate and timely remedy through the administrative process. Both of those two themes are at the core of this. And what the board believes to be the case is that, but for the complaint from a consumer that the board received, which raised questions about whether the appellant in this case had practice, had held himself out to practice, or by implication had represented that he was able to practice, that's why we're here. We're not here because there's an abstract principle that Mr. Mills came to decide that he wanted to bring before the trial court and now before you. We're here because the legislature created a law that empowered the board to not only make the licensing decisions that Mr. Avalor has mentioned, not only to deal with adjudication of compliance issues with those who are licensed by the board, but also to handle complaints that involve individuals who don't have a license. Engineering is an important and learned profession regulated in this state and protected both for the public good and for the businesses and consumers who hire them. But this isn't about the individual's complaint. This is about the board's fulfillment of the delegation that is the laws that have been passed, and the legislature's delegation of power to that board to consider complaints that have been received and then, pursuant to a statute enacted by the legislature and signed into law by the governor, to undertake an investigation, and where those facts support the board's commencement of an adjudication to determine if there is a basis for action for the board to move forward.
Does the board have jurisdiction to address Mr. Mills' due process?
The board, Your Honor, the board has the authority to follow the statute. And if there is a due process question, the board can't make a judgment about what due process is. That's a judicial matter. The board can follow what the courts have said due process requires and can carry that out. And in fact, the legislation that drives what the board does, it embodies those concepts about fair notice, about what's at issue in the proceeding. What is the allegation that's been raised against you? When is the date and time of the hearing? What are the rules of conduct for the hearing? What are the factual issues that are in play? And most importantly, what are the statutes that are in play to support the agency's commencement of its proceedings?
When someone receives a complaint like Mr. Mills has, and they believe or wish to challenge whether the statutory and the regulatory scheme that an agency is asked to apply complies with constitutional rights, be it First Amendment due process, what mechanism or mechanisms could that person invoke to effectuate that change?
Well, there are many mechanisms at this board, and it's a fairly robust structure that this board has. They've got this, that as is discussed in our briefs and below, the Enforcement Advisory Committee process, to allow the agency to delegate now to a subcommittee to review the record, to hear from the complainant, most importantly, to hear from the individual about whom the complaint has been filed, and to review the information that's provided by the complainant, by the respondent, and maybe from third-party sources to evaluate, is this the case that's been raised here in the briefs here, or is it something else? Is this a case in which the individual who filed the complaint, what did he know? What did he understand about what was the credentials and the qualifications of the individual?
And if a respondent, like Mr. Mills and his company, go through that administrative process and challenge final agency action if it's adverse to him and his company, could that challenge include a declaratory judgment claim, or is it too late in the day to do that?
Your Honor, it is not too late in the day. In our view, what we're dealing with here is a situation which, unlike the paradigm that I sketched out here, where you have engagement in the investigative process, as is his right, but with the exercise of any right, carries with it the responsibility and all the consequences that follow. The appellants chose not to engage with the board's investigative process, and so when this matter came to the board, for the board to make a preliminary determination about whether to move forward, they had, except for a short message, they had no information from the respondent. And so the answer, though, to your question is that, sure, the first step, we believe, the first step is through the administrative process, if there were an adverse action, but we're not even yet to that stage. But if we imagine a scenario where the board commenced the proceedings, the hearing happened, a decision was issued, which we don't have in this case, that decision were subject to review on appeal, there could still be an action that would not be barred. And so I think the answer to your question was the judgment below was on these issues. As to the board, were they with prejudice or without? I don't believe, and it isn't the board's position, that there would be a bar to prevent a subsequent action by the appellants in a new proceeding to seek declaratory relief. There may be a question about whether the board is the proper party for that action, and whether the right parties are in this case are the ones that would need to be sued. But we think in this case, because the proximate cause, if you will, the root cause, the but-for test, we are here today, not because the board has a statute on its books that gives it the authority to investigate complaints against unlicensed individuals. The but-for test, why we're here today, is because the board received a complaint against the appellants, and the board undertook an investigation of that case, and we have no record. There is no foundation established for what's the board evidence, what is the board's evidence, or what is the appellant's evidence. For the board then to have made a judgment, as we put in our briefs, that in fact there was not a violation. There was not evidence to support a conclusion that the laws were violated. We're not there yet. No determination has been made. There is no final decision.
Let me ask you to address the argument that Mr. Mills, by literally going through this process, is having his First and other Amendment rights chilled, and particularly with respect to First Amendment rights, courts are mindful of that sort of harm along the way, that shouldn't excuse exhaustion administratively.
And I think the answer to that is that there are inextricably mixed questions of fact and law here. On the record that this court has, a complaint was received which on its face suggests that an individual hired Mr. Mills to perform some service, and Mr. Mills was not licensed as an engineer. We don't know anything of the dialogue that occurred between Mr. Mills and the complainant, between the appellant and the complainant. We don't know what the description was given, what representations were made, what implications were given. And in fact, the opportunity that the board regularly uses its enforcement advisory committee process and its investigative process to tease out the facts, to understand, in fact, if this is a case that merits action by the board or merits no action by the board. And in the great variety of cases, again, no obligation for the appellants to have engaged in that process, but again, in the ordinary process, an individual who has a story to tell that what the board thinks they saw wasn't there to be seen and there's nothing there for the board to do, the board then is equipped and regularly dismisses cases where there is no basis to proceed. But we don't have that record yet developed. We don't have that information because instead of availing himself of the opportunity to resolve this case without the need for us to get involved, as the bond case suggested, without the need for us to turn this into a constitutional debate where the factual development might actually lead us to the conclusion that there was no basis to proceed, instead of availing himself of the remedies and the process that the legislature has put in place that laid out the framework for this matter to be resolved, maybe without an adjudication at all, that path was not followed.
Could I ask, what if Mr. Mills or someone else was part of a profession that was clearly not regulated by the board, and that the board that you would acknowledge would not be subject to regulation, but the board decided nevertheless to initiate an investigation? Would that person have some remedy in Superior Court? Can that person go forward and say, look, they're attempting to regulate, I don't know what profession I could make up here, but I'm a nurse. I'm not regulated by this board. Does that person still have to go through the administrative process?
If we were dealing with the scenario that you're dealing with, which is one that is far beyond this circumstance, there is indeed case law that would allow the court to intervene to check whether the board was properly exercising its authority.
But isn't that essentially what they're saying? What Mr. Mills is saying is that I don't fit within the parameters of what you've been tasked to regulate.
So, and Your Honor, on the facts that you laid out, so it's nursing, right? It's not engineering, it's nursing. And so we would have the question about whether there's a colorable theory or colorable claim that the Board of Technical Registration had any jurisdiction over the practice of nursing. And what we have here is an individual who's made a complaint to the board that falls within the legislative judgment of what is the board's authority, of an individual on its face practicing, holding himself out to practice, or by implication suggesting their ability to practice the field of engineering squarely within the authority of this board, and so different in almost every way from the scenario that you laid out. And what we're here is the legislature has made the judgment that in cases like this that can be resolved administratively, that opportunity exists and is the process to be followed. And so what I would say is that in the nursing case, there may be a framework. We're still not clear about who the proper party for that action would be, but that is not this case. This case is a case that came before this board involving a complaint involving concerns of the area that falls squarely within the board's authority. So because no records exist and because there is no basis for this court's intervention here, we would ask that the court sustain the trial court's decision, because the case law is abundantly clear that when the administrative process does apply, as it does here, that there is an exhaustion requirement that it must be satisfied, and no grounds exist for even the trial court to have stepped in to prevent the board from carrying out, with no offense to the board, with no offense to the appellants or to this court, that this is a garden variety administrative proceeding. This is This is what the legislature put in place in order to provide a framework for the economic regulation and the regulation of economic activity that is the core of board activity throughout the state. And with the legislature's flourish, well, if you will, of adding on this 32106.02 it's really not greatly different from what authority has been given to other boards to deal with unlicensed conduct. And instead of forcing people into Superior Court, the legislature made the judgment in the Technical Registration Act to permit the board to receive those complaints and to adjudicate them, to investigate them first, and to hear from all sides in order to determine whether an adjudication was appropriate. And we believe that the appropriate step is not to prevent the end run and not to permit the failure to scrupulously follow the administrative process, but to allow this case to proceed as the legislature has set in place, and we can have the conversation that would allow the record to be developed, that if Mr. Mills and the appellants wish to pursue these claims that constitutional freedoms have been put in check, there is a process for that to occur. And that is the process that we think should be followed.
And there is no currently pending formal hearing, request for formal hearing, scheduled for formal hearing at this time, is that correct?
That is correct, Your Honor. Yes.
And do you wish to be heard on the judicial notice? It struck me that your position was either slightly or somewhat different than appellants.
Well, our position, Your Honor, our position on the judicial notice was it's after the adjudication has occurred. It is not really relevant to this matter. It's not part of the record. And the additional information that was asserted or implied in the request for judicial notice suggested an argument or a belief about the board's orientation to the case that we did not think was appropriate. So we don't think the judicial notice is necessary or appropriate. But there are no, in answer to your question, there are no pending matters. There is no case that has been filed, and in fact, if there were, that would probably have made it into the record by now. So we asked that the court sustain the trial court's decision. We believe that the dismissal was appropriate. We believe that the administrative process should be permitted to run its course. And thank you very much for your time.
Your Honors, a couple of points in rebuttal. First, the board just said, look, we think that there's adequate and timely remedy here through the board, adequate and timely. And what was that remedy? The remedy was the board says we can dismiss the complaint. Greg's complaint in Superior Court does not ask for the dismissal of the complaint. It asks for a declaration as to the constitutionality of the laws, an injunction, and nominal damages.
But why isn't it an adequate remedy to go through the administrative process? Why not understanding why it would be necessarily lengthy or costly to make your point that I'm not regulated by you. You can't do this, get a ruling, and then go to Superior Court.
Your Honor, that's one, not adequate because it doesn't actually give Greg the relief that he seeks through the courts. The declaration. That's not something the board can give him. As the board just said, we can dismiss the complaint. That's not the basis of this case. The basis of this case is my rights have been called into question under the existing statutes, and they will continue to be called into question until a court construes the meaning of the statute.
What do we do with the legislature's legislative decision to task a board with making findings when and they referenced engineers specifically?
The board.
Your client is an engineer.
So the second part of that, Your Honor, is that the courts have always said you don't have to go to the administrative process for certain kinds of claims where there's not an adequate and timely remedy available through the administrative process. That's the McDaniel case that involved this very board. But I'd like to come back to the timely point, Your Honor, because again, there's no case in Arizona that says a ripe constitutional injury has to wait. Again, today, Greg's activities are chilled by the existence of these laws, which potentially, according to the board, regulate his activity. And therefore, under the DJA, he is entitled to an early resolution of that, to give him the forewarning that is required. Otherwise, he faces the classic choice of ripeness, which is I stop talking and working, or I continue to work and to speak and subject myself potentially to future penalties as well.
But he goes through a trial in Superior Court to make all the points that you'd like to develop the factual record, as opposed to developing the factual record before the board?
Developing a factual record before the board, which then this court or the courts cannot be bound to. Again, because the boards do not have the freestanding ability to just find facts. That's a judicial function. I'd like to call Your Honor's attention to some specific language on this in the Manning case, which is, it talks about the different remedies between attacking the validity of an ordinance and securing essentially a variance from, in that case, a zoning ordinance. But the key point is that challenging the constitutionality of an ordinance is based on right and entitles an owner or someone who's subject to this to a court trial on questions of fact. While the latter, where you're seeking a favor from the government, that's what administrative exhaustion is for. That's what Moulton says, that's what Manning says, that's what Valley Vendors say. They all say that same thing. Again, there is no adequate and timely remedy here in front of the board because, again, the board's position is he has to sit back and wait. Sit back and wait is not administrative exhaustion. We talked about Manning, we talked about the relief. We've not talked about the notice of claim issue. If Your Honors don't have any questions about that, I'm happy to stand on our brief. And finally, Your Honor, I would like to just note that there are, if this court thinks that administrative exhaustion is required here, this opens the door to a number of further questions that this board would have to address. Primarily, does the board have the constitutional authority? Is it a violation of due process and separation of powers to allow the board to adjudicate, again, as the board's word, Greg's rights? Your rights, you can be stopped from speaking, or you can be stopped from working. Those are the sorts of rights that only courts are allowed to determine. Boards don't have that authority. Again, boards are limited to determining government benefits, public rights, the sorts of things that come under that heading. There's a case that didn't make the brief, Your Honor, and I'm hoping that I can just point you to it. Southern Pacific Company versus Cochise County. It's it's an Arizona Supreme Court decision from 1963, 92 Arizona 395. It's cited in the Estate v. Bone case. And that one, again, recognizes the distinction between essentially seeking relief that is a government benefit or a favor sought in the terms of Manning versus an actual assertion of a private right, a constitutional right. And that's what's at issue here. Your Honor, for those reasons, there is no adequate and timely administrative remedy. There's nothing that Greg can ask the board for and nothing the board can give him that will remedy the injuries that he has alleged here, that will provide him the relief that he seeks here. This is, as the complaint itself points out, not about the complaint. This is about the constitutionality of the statutes that regulate Greg's work and his speech, and he is entitled to have a court determine those questions. And if Your Honors have any further questions, I'm happy. But otherwise, we ask this court to vacate and reverse. Thank you.
Thank you both for your argument. We will take this matter under advisement and issue a decision in due course. And with that, we will take a short recess.